Hello, this is just some general bankruptcy information, and I'm not providing legal assistance. I am providing you with information that's available to anybody if you just look for it. Bankruptcy law is a federal law. This sheet provides you with general information about what happens in a bankruptcy case. The information here is not complete. You may need legal advice. When you file bankruptcy, you can choose the kind of bankruptcy that best meets your needs, provided you meet certain qualifications. Chapter 7, a trustee is appointed to take over your property. Any property of value will be sold and turned into money to pay the creditors. You may be able to keep some personal items and possible real estate depending on the law of the state where you file and applicable federal laws. Chapter 13, you can usually keep your property, but you must earn wages or have some other source of regular income, and you must agree to pay part of your income to the creditors. This court must approve your repayment plan and your budget. A trustee is appointed and will collect the payments from you, pay your creditors, and make sure you live up to the terms of the repayment plan. Chapter 12, like Chapter 13, but it's only for family farmers and family fishermen. Chapter 11, this is used mostly for businesses. In Chapter 11, you may continue to operate your business, but your creditors in the court must approve a plan to repay your debts. There is no trustee unless a debt decides that one is necessary. If a trustee is appointed, the trustee takes control of your business and property. If you've already filed bankruptcy under Chapter 7, you may be able to change your case to another chapter. Your bankruptcy may be recorded on your credit record for as long as 10 years. It can affect your ability to receive credit in the future. What is bankruptcy discharge and how does it operate? One of the reasons people file bankruptcy is to get a discharge. A discharge is a court order that states you do not have to pay most of your debts. Some debts cannot be discharged. For example, you cannot discharge debts for most taxes, child support, alimony, most student loans, court fines and criminal restitution, and personal injury caused by driving drunk or under the influence of drugs. A discharge only applies to debts that arose before the date you filed. Also, if a judge finds that you received money or property by fraud, that debt may not be discharged. It's important to list all your property and debts in your bankruptcy schedule. If you do not list a debt, for example, it's possible the debt will not be discharged. The judge may also deny your discharge if you do something dishonest and connect with your bankruptcy case, such as destroy or hide property, falsify records, lie, or if you disobey a court order. You can only receive a Chapter 7 discharge once every 8 years. Other rules may apply if you previously received a discharge in a Chapter 13 case. No one can make you pay a debt that's been discharged, but you can voluntarily pay any debt you wish to pay. You do not have to sign a reaffirmation agreement or any other kind of document to do this. Some creditors hold a secured claim. For example, a bank that holds a mortgage on your house or a loan company that holds a lien on your car. You do not have to pay a secured claim if the debt is discharged, but the creditor can still take the property. What is a reaffirmation agreement? Even if a debt can be discharged, you may have special reasons you want to promise to pay it. For example, if you want to work out a plan with your bank to keep your car. If you promise to pay that debt, you must sign and file a reaffirmation agreement with the court. Reaffirmation agreements are under special rules and are voluntary. They are not required by bankruptcy law or by any other law. Reaffirmation agreements must be voluntary. must not place too heavy a burden on you or your family, must be in your best interest, and can be canceled any time before the court issues a discharge or within 60 days after the agreement is filed with the court, whichever gives you the most time. If you are an individual and you are not represented by an attorney, the court must hold a hearing to decide whether you approve the reaffirmation agreement. The agreement will not be legally binding until the court approves it. If you reaffirm a debt and then fail to pay it, you owe the debt the same as if there was no bankruptcy. The debt will not be discharged if the creditor can take action to recover any property on which it has a lien or mortgage. Creditor can also take legal action to recover a judgment against you. And the trustee is not responsible for giving you any legal advice. Thank you.